our first Fireside chat, which will be on DAOs and regulation. Our moderator is Rebecca Rettig, General Counsel of the Aave Companies, a group of software development companies in Europe that builds open source blockchain-based software. Rebecca began her legal career at Cravath, Swaine & Moore in New York, litigating complex commercial disputes and defending regulatory enforcement matters. Prior to joining the Aave Companies, Rebecca was a partner at Manat, Phelps & Phillips in the financial services group, representing blockchain and crypto clients. Rebecca, it is great to see you. I will turn it over to you.
Thanks so much for having me, Kristen. And thanks so much to my esteemed panelists, Miles Jennings and Bill Hinman, to talk about DAOs and regulation. I'd like to start off by giving them each an opportunity to introduce themselves. Bill, do you want to start? I think you're on mute.
There we go. Hello, everyone. It's great to be here today, and thanks to the folks at Stanford for inviting us. My name is Bill Hinman. I had practiced law in Silicon Valley for many years, and always in the private sector. And then in 2017, joined the SEC as the Director of Corporation Finance. There, I was fortunate enough to be able to make some policy related to crypto. We launched a framework in, someone's phone is ringing. It's not mine, I'm sorry. We launched a framework for how you analyze when is a complex instrument like a digital token security, and did a few other things that we'll talk about later, but spent about 4 years there, and again, really enjoyed this area of focus. And since then, I have joined Andreessen Horowitz as a senior advisor, and also I'm affiliated with my old law firm, Simpson Thacher. So great to be here today. Thank you.
Thanks, Bill. Miles?
Yeah, hi, I'm Miles Jennings. I'm general counsel at the A16Z crypto group. Previously, I was a partner at Latham & Watkins, working in their emerging companies and capital markets group, where I was, working in this space. Got started in around 2017 with Consensus, and now here at A16Z, I get to work with Bill. I like to joke that I spent the last 4 years trying to figure out what Bill's words meant, and now I can kind of just call him up and ask him. So it's been a real pleasure.
Well, hopefully we'll get some of that great insight today, as well as we talk about DAOs and regulation. But, obviously there have been, over the past few days and today, there are all aspects of DAOs that are being addressed. Obviously treasury management, structuring, things like that. But today, as Kristen said, we're going to talk about all legal and regulatory matters as they relate to DAOs. And I think it can't be avoided, just given how prominent the question of law and regulation is as it relates to the blockchain, crypto, DeFi, Web3, whatever we want to call it, that space, as it pertains to today and everything we're working on. So let's start sort of at the very baseline by talking about the legal structures around DAOs, because there's been a lot of talk of it late, and new tools and new ideas being put out there. But just from a very basic perspective, and let's start with you, Miles, from a legal perspective, what considerations should be thought about when people are setting up a DAO, right? So even something like Constitution DAO had a particular structure,
Sure.
But there are others like a typical DeFi DAO as it relates to a protocol, and that will have a very different structure. So what things should people be thinking about?
Yeah, I think as a starting point, right, I would say that there's no one size fits all approach, and I think that is one of the complicating factors in trying to kind of work in this space, right? Is when people say DAOs, they mean a lot of different things, and as a result of that, right, there are a lot of different entity structures, just like there are for businesses in the real world. And so, one of the ways that kind of I look at it, right, is trying to look at what the underlying business is actually, trying to achieve, and whether or not like they're actually, there is a purpose to the decentralized nature of what they're doing, rather than, you know, maybe being like, for instance, there are charities that are setting up that are, a DAO might be just an advisory board, right? And so it's like, where exactly is the decentralized nature? What is the purpose of it? And what is the purpose of the overall business? If there are, you know, analogs for in the real world for the thing that the DAO is trying to accomplish, then it's very likely that the legal structures that are used for those you know, real world entities are going to be applicable there. So for instance, you know, with investment DAOs, where you have a group of people that are coming together and investing, you know, oftentimes LLCs are going to be the best choice. And that's what, you know, Wyoming's DAO bill does. That's also what Tennessee's DAO bill does. And then, you know, if you have more of a collective, then it might be a co-op that's the best structure. And then for, you know, protocols and networks, I think that there's a couple different routes people have taken. The three predominant ones, or the two predominant ones, are entity list structure, and so just not having an entity whatsoever. And that, you know, the genesis of that was really coming out of kind of like the, you know, the layer one chains like Bitcoin and Ethereum not having, you know, any legal entity associated with it. And then there's, you know, and then moving from there, you have a lot now of foreign foundations that are being set up to basically act on behalf of the DAO, and they take direction from the DAO. So really, you know, at the end of the day, it's about trying to figure out what the purpose is, and then going from there and finding the right legal wrapper.
Yeah. Bill, other considerations that people should be taking into account when they're thinking about setting up DAOs?
Sorry, I muted myself because that phone keeps going off, but hopefully it won't happen again. I think that, you know, one of the things that you need to think about is, in terms of those various factors that Miles is highlighting, is, you know, are you concerned that what you're doing with your DAO at the moment might raise SEC scrutiny? You know, DAOs in some respects have been attractive because folks have really latched on to something that we had articulated back in 2018. You know, if you have an organization where there's not an identifiable active participant or sponsor or third party that's really directing how the DAO's success might go, then you might not have something that gets regulated as a security. And back then we said, you know, Ethereum had reached the point, even though it's not a DAO, but Ethereum had reached the point in terms of an investment in a token that did not need to be regulated as a security, because there wasn't a central party sort of directing the activities, and people weren't relying on a central party to deliver them a return, which is one of the keystones of whether or not you have a security. If you are setting up a DAO and you feel like people are not giving you money as an investment to get a return from what you do as an organizer of this DAO, and you're staying actively involved, you know, that may dictate one way in which you manage tokens used on the DAO and the structures that you pursue. The more you need to have, especially at the outset of some of these enterprises, the more you need to have some central actors involved, the more careful you need to be around the transferability of the tokens and whether or not you're going to get scrutiny as a security by the SEC. So again, if there's high level of utility, people are not buying this as an investment, and they're buying into the DAO because they want to be part of this ecosystem and get its functionality, and they're not relying on a third party to return, that probably gives you more degrees of freedom and transferability and other structural concerns that you might have with your DAO. If you are still actively involved, people are viewing it as an investment opportunity, then you might be thinking about limitations on transferability of the tokens, at least for some period of time, until you get past some of those startup issues and the functionality of the DAO is there.
Yeah, I have so many questions that have come out of all of this. So let me try to unpack them bit by bit, because I really do want to dive into the question of governance tokens and active participants from the FinHub framework as well with you, Bill. And I know that people are starting to pose questions. I will monitor them. I think some of them are going to come up organically in terms of what will be answered, but we will also, I'll save probably about 10 minutes at the end so that I can get to everyone's questions as well and moderate and parse through those. So Miles, just to go back to what you were talking about, and in recognition that you just wrote a very interesting article about decentralization for Web3 builders, principles,
Yep.
models, how. Everyone should definitely go take a read of it.
I didn't do the
because-
title, just.
That's okay. I was just saying it so everyone could make sure they find it okay.
Yeah.
But you break down decentralization into three aspects: technological, economic, and legal. But talk about why. I will drop the Miles link there. Good idea, everybody. But talk about the intersection of the three of those, particularly with respect to why having all of those is important. And from my perspective, and as I think about decentralization, the legal part just permeates even the economic and the technological.
That's
as
right.
well. Yeah, let's talk through those.
So I think that's right. I mean, as Bill was kind of just explaining, right, I think that the way that I break it down in that paper is looking at like technical decentralization, economic, and then what I call legal, right? The technical is really, can you technically be decentralized, right? Blockchains and smart contract protocols really allow for that by creating kind of contracts that have very hard-coded significant commitments that they can make, and that people can't go out and change. And so as a result of that, it lays the groundwork for having decentralization. But one of the key elements, as Bill was just saying, right, is that you have the ability to basically hand control over those things to a decentralized group, right? And DAOs are the best way that we have to do that, because without a DAO, right, then you would have control by an individual, and if you had control by an individual, then it's unlikely that someone is going to trust, right, that smart contract or that chain is going to continue to act and exist the way that they want it to, right? So you always kind of, wherever there are points of centralization, you end up with points of potential trust, and where there is trust, right, there is the potential for the breakdown of trust, and as a result of that, it's less likely that those things are going to kind of redo the internet like we think that they're going to. And so, really, like when it comes to DAOs, right, they really do play a role in in all three areas of decentralization: in the technical, in the economic, and the legal. On the technical, right, they basically turn control over the smart contracts to the DAO. On the economic side, right, you are going to have more faith in a system in terms of its overall, like, the decentralization of its economy, the fact that it's, accruing value to people equally or in an equitable way, right? You're going to have more faith in that if it's done through a voting and representation system than if it was just a, dictator, one person doing it. And then on the legal side, it forms the basis of removing kind of people providing managerial efforts. And that's part of the Howey test, and we'll get into that. But so really, like, DAOs are the best tool that we have to kind of hit all three of those elements. And without them, right, there's really not a great way to actually achieve decentralization of these systems.
Right. And to set up sort of the decentralization within regulation point for Bill, and to talk a little bit about the framework for digital assets that came out from FinHub in 2018. When I think and talk a lot about regulation in the context of, comparing it to how decentralization works today, all the securities laws are written with the word person in them, right? And person means a natural person or some sort of corporate entity, which makes sense because the way that our financial system has worked, or the legacy financial system has worked for many years, is with intermediaries in mind. But now when you have decentralization, you have to think about how those regulations do or do not work and apply. And so, Bill, to go back to what you were talking about with respect to having, either a diffuse group versus a central intermediary, when FinHub, the SEC's FinHub, put out the framework for digital assets, they had a concept called active participant, or AP, I think as a proxy, right, for this concept of having a centralized intermediary. So can you talk a little bit about how APs work in the DAO perspective, why we think about them as important or not, and how it relates to, let's put into context, governance tokens today?
Sure. So just to step way back, and I think many on this call are very familiar with what has now become, a famous Supreme Court case in this area, the Howey test from the Howey case. The Supreme Court there had to apply the securities laws, which, as you say, are somewhat prescriptive and have a lot of defined terms, but For one thing, they don't mention anything about orange groves or interest in orange groves, and they don't mention anything about digital assets. And so the SEC was taking, and in front of the Supreme Court was taking a very principles-based approach to, when is an instrument that you might purchase by giving someone else some value going to be construed as a security. And the key concept that they came away with is if you're giving that money to a third party and you're expecting them to generate you a return, then that is an investment contract. Investment contracts are defined as securities. The concept and the reason why people think that type of arrangement requires regulation as a security is that when some third party is the one doing all the effort and creating the return for you with your money, they know a lot more about it than you do, and they're taking your money. So the securities laws are there to say to that person, let someone who you are having fund your project, let them have all the material information around that project, all the risks, all the prospects, and do it in a way where you have liability if you're misstating it. That is the basic idea behind the securities laws, which works pretty well. And considering that they were passed in 1933, it's a pretty flexible set of principles that can encompass a wide range of arrangements where there may be these information asymmetries between the people who are giving up their money to some third party and saying, go do something for me with it, versus themselves, and they may not have all the insights that the central party has. If you think about DAOs and you think about digital assets more generally, the people that you're sometimes relying on to make that system work could be highly diffuse. Could be the mining community, the system in general, which only stays connected through things like Reddit, which are very visible, and there's everyone who takes the time can learn, and there's not a lot of opportunity for information asymmetries. Or there can be still a very small group of sponsors who have started the project, retain a strong economic interest in the project, and are sort of overseeing its success. And in raising the funding for that project, they may have even sold it as as an investment opportunity. In those circumstances where there's still this group that people may be relying on and may have more information than they do, the SEC is very apt to come in and say, we still think you have a security. So the legal concept is this kind of soft, principle that can expand and contract, but it's basically trying to make sure that people are not giving up money into a system and expecting others to generate a return, and that those people have more information. Excuse me. So the concept of legal decentralization fits nicely into, Web3 and DAOs and digital assets generally, because those are generally decentralized communities. It's not perfect because, as we all know, you can't just start something and have it, kind of out of thin air, be a well-functioning protocol, have good rules of governance, sort of make changes over time, protect the software from being hacked, all of that, without some group that is probably somewhat centralized and very focused on its success. And so, we look back, the very first, utterance of the SEC on DAOs was something called the Dow Report in 2017, where there was, the original DAO that got hacked, and the SEC looked at it and said, even though this is organized as a DAO, we still see the folks behind it, I think it was Slockit, are still very actively involved. They have a lot of control over who gets to propose projects to that particular DAO. They had a fair amount of influence on the governance generally. People were, in effect, relying on what Slockit had told them about the opportunities. Slockit had put together the marketing for them. And so the SEC said, we actually think, even though this is characterized as a DAO, and I would commend anyone to go back and read that, because it gets very detailed in terms of the various things they did that the SEC was concerned about. Yeah, when you have that much level of control over the DAO through a small group, the securities laws will have a role. The 21A report, which is what the DAO enforcement action was characterized as, it's called the 21A report because the staff doesn't, in these particular reports, doesn't apply penalties. They say it's early day. We said it's early days of enforcement in this area. People may not have fully appreciated the analysis. And so we're going to say, at least with respect to this one action where these principles are first being applied to DAOs, there'd be no penalties. There was also a way to fork Ether at that time in order for folks to get their money back from the hack that had happened. So it was a good place for the SEC to say, here's some of our thinking, and we won't apply penalties. Going forward, people wanted to know more, and they wanted to know it not just in the context of DAOs, but in general, how does the staff look at digital assets and determine whether or not they're securities. And we formed a group within my division called FinHub, headed by Val Sapanic, who understands the space very well. And together, we all came up with a number of principles that you could go through to see whether or not your particular digital asset might be viewed as a security by the SEC. That's really the last time the SEC has spoken in any detail on this. And it hasn't really had the opportunity to apply some of that analysis to a group operating as a DAO. But most of what's there in terms of DAOs will be dependent on whether or not that DAO has still a group of people they can identify, and the framework identifies this group as active participants. It was a term we just kind of made up, to say somebody is in the middle of all this and still controlling the success, and people who buy the digital asset that trades on that DAO are relying on this group. This active participant group is active enough and involved enough that there's information asymmetries, and there is a reliance on that group where the securities laws would have a role in protecting people who buy that particular asset. And then Miles can talk a little bit more about how you can try to structure the DAO. So the role of the active participant is not one where people would logically say, oh, you're relying on that group to generate you return. You may be relying on them for a ministerial set of chores, but there's not anything that group controls that's so important that whatever they know about what they're doing needs to be shared in the context of the securities laws, and that it's ministerial and it doesn't quite meet the Howey test. But that's a very tough analysis. It's somewhat subjective. And it's one of the areas where I think we're all hoping that the securities laws are clarified further, so that people have the certainty on how to stay in compliance, but still allow some functionality by some group in the context of a DAO, where people can do some things that help it along, but they're not viewed as active participants in creating a security out of the DAO instruments.
Yeah. Miles, jump in, but then I have a very specific question about the Dow report that always sort of stays in my head as we think about the evolution of DAOs. But Miles, feel free.
Yeah, sure. I mean, I just jumping off what Bill was saying right there at the end. I think that what he was saying right around kind of how DAOs are structured. I mean, really one of the ways that you can think about it, right, is whether or not kind of the way that your DAO is being set up and how you're kind of, forming your decentralized governance is really looking at kind of whether or not you're going to have potential asymmetrical information accrue to any individuals, right? So one of the ways that, there are lots of different tests that people have proposed that kind of implement what, Bill was talking about. One is the Bahamas test, where if everyone, on a team or, a group of people all disappear to the Bahamas, would the technology continue to kind of subsist and sustain itself, which I think is a useful way to conceptualize it. Another one is, is there a member or group of the DAO, right, that would be able to kind of rug the system, right? Would they be able to basically manipulate it for their own benefit? Wherever there are these like potential pockets of asymmetrical information, right? If you know that you have that ability, or know that you're about to do something that is going to seriously change the price of the token, right? Then the application of securities laws is probably proper, because otherwise people will take advantage of potential investors. I think that the last point, right, is like this information asymmetry point is also one that you can take into account when you're thinking about economic decentralization, because ultimately, if, you know, the same way that if you're able to kind of rug investors, if you're able to like rug participants in this ecosystem, right, you're overall kind of limiting the decentralized economy of the system, and therefore making it less likely that people are going to build on top of it and utilize it in their own work. And so as a result of that, right, again, kind of the harmony between the securities laws and kind of what you want from an economic decentralization perspective are kind of right aligned. And it, you know, is kind of very fortuitous that is the case.
Yeah. So just to go back to the Dow report a little bit, and it really does look at the Howey test, which is, you know, was there an investment of money? Yes, people bought into the Dow token in a common enterprise. I think the SEC says the common enterprise almost always exists, so that doesn't get into a lot. Were people expecting a profit? They found yes, and then it was from the efforts of others. That's the general Howey test. And on the efforts of other part, they said, yes, everyone was relying on Slockit's co-founders and the curators for their efforts. But it did have this other interesting part, which people don't focus on, which is there are DAO token holders. They could vote. And why weren't the DAO token holders enough to sort of overcome Slockit's and the curators' efforts and the efforts of others prong? And what the Dow report says is the voting rights afforded DAO token holders did not provide them with meaningful control over the enterprise because, one, their token holders' ability to vote for contracts was perfunctory. Okay, that's understandable, right? Like it was just for show only and everybody else. But then the second thing they say is DAO token holders were widely dispersed and limited in their ability to communicate with one another, which is back then, so in 2017, seen as a bad thing. And today, I feel like we really focus on and care a lot about that there is a lot of disbursement among token holders for a governance DAO, and that they do not coordinate with each other, and especially not with the founding team and stuff like that. So how do we think, Miles and Bill, about this evolution from that not being a great thing to now being, you know, something we want to make sure we see in DAOs today?
Yeah, I can start maybe. You know, one thing that is behind the conclusion that the voting rights are somewhat perfunctory was the role that the Slockit designated curators played and how things were put up for a vote. So that a lot of proposals had to be, you know, first vetted by them. And so that gave them a lot of control what was actually put up or not put up. And they also had a mechanism where if you voted no, you had to leave your tokens in the system for some period of time. You couldn't transfer them. You were kind of tied up while that particular proposal was being worked through. And it was easier to abstain than it was to actually vote yes or no on a project. So people had a great sort of incentive to either abstain or vote yes on a project. And so the democracy of that voting system was somewhat you know, suspect, I guess, in the eyes of the folks in enforcement. So I think you're right, Rebecca. I do think a diverse group of people voting is usually helpful. The staff made that observation that this group is so dispersed that they would possibly have trouble communicating with each other. I think that's a little dated now in terms of there is, you know, we do see, you know, folks through Reddit and other channels being able to communicate pretty effectively. But I think they felt like at that point, the disbursement was a problem given how the system was set up and sort of tilted in favor of these Slockit selected curators to manage the outcome, that the vote was less important than it could be. And I think a properly designed governance system and in recognition of the ability of folks to communicate with each other if they need to sort of outweigh one particular participant. I think it's probably a little bit of a different framework today on communication than it was back then. I would not be too worried about, okay, we have a dispersed group of folks voting and that's not a good thing. No, I think that remains a good thing.
Yeah, just to echo that, I mean, I do think that the tools that are available now are a lot better, and that DAOs obviously spend a lot of time trying to get people engaged. I mean, snapshot voting, right? I will say there's not a tool in the space that makes me feel older than Discord, but obviously it is a really good tool for people to be able to use. And then I also think, it's an area where, guidance from the SEC, I think, would be very valuable, because there are a lot of different, ways that people have designed governance, and yet we've gotten no real, feedback on what's working and what's not. Like for a lot of the foreign foundation structures, in order for them to get the benefit of limited liability, they actually have to, act through the foundation, which involves a board of directors there. And so, you could see that being a problem if those boards of directors had kind of permanent roles, right? But one of the things that a lot of DAOs do, right, is basically make it so that they can replace those directors at any time. And that kind of negates some of the control that those directors do have. And then, there are other kind of proposals that, Optimism just came out with a very interesting structure where, they basically have a bicameral legislature, and one group is kind of more looks like a House of Lords, for instance, where it's kind of a stewards for the organization and the layer. So I think, overall, like, this is an area where I think that there's a lot of room to explore, and it would be, great to get, more kind of out of the SEC in terms of guidance to kind of give people direction on where to be headed.
Yeah, that makes a lot of sense. So I want to make sure we get to questions, but my last one goes to what you talked about, Miles, which is, there are these new foundation structures and other legal structures to wrap DAOs. So I'll ask my question as well as an audience question, which is, can you talk to us just a little bit about the tools that are coming forward as DAOs evolve, and sort of the pros and cons of that, as well as just to answer one of our listener questions, which is, in what situations would you need a legal wrapper around a DAO versus not?
Sure. So I think there are a lot of good tools that are being developed. I think Syndicate and KlimaDAO are both kind of, or GiliDAO are two that are building tools to allow kind of people to form DAOs very quickly and effortlessly. And I think that is really good. One of the issues with the foreign foundation structure that a lot of DAOs use is that it's very time consuming and resource intensive. You have to have multiple firms, they're international. You have to have an international accounting firm, and it takes months, and there's a lot of kind of hurdles that you have to go through. And so as a result of that, it's not kind of the most accessible pathway for a lot of DAOs. And one of the structures that I've been writing about and working on is an unincorporated association, which is one that we kind of want to make available. I think on KiliDAO they actually do have a unincorporated association that you can form, and so I think that the tooling for this stuff is getting better. I think there are tax paying tools that need to kind of come to fruition to make the lives of DAOs easier. But people are building payment tools. There are companies that are building out, like Deal, that are building out, allowing DAOs to basically employ people all around the world. So the tooling is getting better. KlimaDAO, sorry. There's a lot of stuff out there that people are working on that I think are making DAOs a lot easier to use. And I think that, we'll all benefit from that, because I think that the more that people can kind of explore these structures, the better off the industry will be. And what was the second question?
The second question was, when do you or do you not need a legal wrapper around your DAO?
Sure. So I think that the three kind of challenges with not having a legal wrapper at all, right, are legal existence, limited liability, and an ability to pay taxes, right? So those are three things that you really can't do unless you have a legal entity. And the legal existence one means like an ability to contract and actually form, legal obligations. So, what I would say for all three of those, right, is you really have to look at what the nature of what you're doing as a DAO is. If you're just a group of people that are formed around a Discord, you probably don't need a DAO. But if you are a group of people that are overseeing kind of investments, there's income to the DAO. If you're taking actions that you could like potentially have liability for, like a social club DAO, right? These are all things that require legal wrappers because ultimately, your assets live in the real world, and liability will exist in the real world. And one of the things that we're starting to see is a lot of big uptick in class action and private lawsuits. And so as a result of that, getting a legal entity wrapper protection for yourself is something that is really important.
Yeah, that makes a lot of sense. Bill, to go back to this concept of, I'm going to try to wrap a few audience questions into one, but to go back to this question of disbursement and the creation of DAOs and active participants, two parts to it, which is today, you'll have a DAO, but you'll also have a smaller multi-sig that could pull a trigger if something happens, it can act more quickly in let's say an emergency situation than the DAO can, in either pausing or shutting down the protocol. And, is being a multi-sig holder akin to being a curator here? I would argue no, but everybody is interested in your opinion on that. And then similarly, is having sub-DAOs and the ability to delegate, good from a disbursement and distributed point in the DAO system?
I'm sorry, could you say the last part again, the last question?
Sure. So the first question, right, is are multi-sigs like the curators? The second question is, what has happened these days is you have sub-DAOs under the DAOs. So you can have risk DAOs, dev DAOs, grants DAOs, who are doing sort of these smaller functions and are made up of smaller groups of people from the larger DAO. Between that and the idea of delegation generally, what does that do for or against the active participant concept?
Yeah. So to cover the last one first, I think it can be helpful if somehow that enhances the functionality of the ecosystem without concentrating the control within some identifiable group that the SEC could say, that's our group of active participants, because so many different things that this particular DAO happens to be doing are done by different groups that rotate over time, and they have certain functionality, and it's reasonable to expect that these different collectives are not necessarily the active participants that people are relying on when they buy that token. They want to see the functionality that's being executed by these different sub-DAOs, and there's a group of people that may be in and out of those from time to time, but no one group is all that material to the total success of the overall DAO. So I think that's likely to be helpful. Where it could come back to be not so helpful is if the major, the mother DAO is in effect still controlled by some smaller group that's easily identifiable. And I'll use that to a segue into the multi-sig question. I think if the multi-sig signers are dispersed enough, not so heavily invested, and all they're really doing is signing accounts for the legal entity that they may have wrapped themselves in, that should by itself not likely be enough if they're not decision makers in terms of what they are doing generates a return. Where it gets a little trickier is and I think this often starts out to being the case, the multi-sig signers are also people who have a pretty strong vested interest in the success of the DAO, because they've either retained a number of the tokens or they were there at the beginning, and for whatever reason, they have a strong interest in seeing its success. And then they also happen to be the folks that are most active in new proposals, and and they become identified with the particular DAO, and what they say influences how it trades, influences people's levels of comfort. Then I think the signature role here is not going to be a helpful one. It'll probably be used because it's just so easy to identify as an important tool to sort of find who the active participants were. But I think you need to do more than just be the signer on a multi-sig arrangement.
Yeah, great. So to try to bring a lot of the questions together, I litigated many securities cases when I was in private practice, and I can say the Howey test is extremely fact intensive and very nuanced. And so the question that a lot of people are asking in the Q&A, and we'll start with you, Bill, is will we ever be able to have regulators sort of pare down for us what decentralization means and look like in terms of some meaningful guidance? I'm not even asking about this SEC, but just from a concept of decentralization, the Howey test, and everything you've worked on in the past, and thinking about what's coming down the pipe. Is it something we can hope to see?
Hope springs eternal. So yeah, you can always hope. I think and I sort of said this at the beginning, these tests are so broad and they're so qualitative that there will always be some uncertainty unless the regulators either give some real clear guidance, which we don't see happening for some time, or the legislature tries to draw some lines for people. In the meantime, if we're just dealing with today's law and the guidance that we have there, I'm not optimistic that it's going to be really clear that this will work and that won't work. People are going to need to weigh in with more. And as they weigh in, not to blame the regulators too much, they're always very worried that if they draw brighter lines, that people will go right up to the line. And they may not capture something which in hindsight they wish they had. So they're always very reluctant to draw some bright lines. So it's more likely that we'll see something through legislation or maybe some court-made law where the SEC pushes something and the court disagrees. But it's hard to imagine a lot of good guidance coming out that made people feel like they had a super high level of certainty on some of these points. I think we're always going to come back to those general principles of, are people relying on somebody else, and does that somebody else have more information? And then wherever there's a situation where something goes wrong, there's a problem, then the SEC works very hard to apply these broad principles in a way to find a way to protect investors and to apply the law and say, that was enough. That looks like a security to us, and bring an action. And oftentimes they don't have to litigate those, they get settled. So, they feel like they're playing a role in protecting investors without ever necessarily clearing up the law enough for the people who are trying to follow the law and do good things. So it's a difficult environment for a while. And we all hope that the regulators and the legislators recognize the value of this and help us sort of navigate it. And that will probably require some clear legislation and maybe some guidance, but maybe court law.
Okay. So mindful that we are at the end of time, and I know we didn't get to all the questions, but Miles, and I think this probably could have been twice as long, and we still may not have gotten to everyone's questions because this is such a nuanced hot topic. But Miles and Bill, are there anything you want to leave our audience with today just about DAOs and regulation and building in Web3?
No, I think that there's a lot of promise in DAOs. I think that there are a lot of people that are very excited about them. I do think that there are good resources out there, the ones I mentioned, Syndicate and Cali DAO, and that people really need to kind of, before they jump in and form a DAO and kind of raise money from people, right? Really, you do need to talk to a lawyer, because ultimately, there are all sorts of confluences like tax and law and all of this stuff that really is challenging to deal with. And we're working on those pathways to make them easier. But at this moment in time, right, it's really important to find the right advisors to help you along the way. There's a lot of promise, but there's also a lot of uncertainty.